Yes, call next.
Item number 1.
Yes.
My lord, this is an application for condonation of delay, my lord. My lord, on the last occasion, liberty was...
8,000 days.
My lord, on the last occasion, liberty was granted to file an additional affidavit explaining the delay, my lord. I'm praying for some more time, my lord, to file.
No, nothing to delay. This cannot be. You have seen your grounds of review.
My lord.
Just because a division bench has taken a contrary view to the other division bench, that cannot be a ground of review.
No, my lord, our
Shows the
main
law.
ground
Yes.
is, my lord...
You have referred to a judgment of the Guwahati Law Times
My lord.
of 1988.
But
That was your
our
ground
ground
of
is, my
review.
lord, that the evidence has not been laid, my lord, but the honorable
That
division
cannot
bench
be a
has...
ground of that judgment cannot form the basis of a review.
My lord. My lord,
They have on the basis of the whatever the evidence is there, they have decided.
My lord, the evidence has not been laid at all, my lord. No witnesses has been called, my lord. But the
That
division
may be a
bench has...
ground for that may be a
held
ground.
that-
Your SLP was also dismissed.
My lord, my lord.
Then SLP was not admitted.
It was not admitted.
Suppose whatever points you have urged there in the SLP, the SLP was dismissed also. So you must have taken the point in the SLP that the evidence was not there before the division bench and it was considered. Sorry, madam.
My lord, my difficulty is, my lord, I am led by senior counsel Mr. Paul, my lord. So he is
Very
not
well.
here today, my lord.
You
My lord,
would not have changed the
My lord, we'll fix it next week,
outcome
my
of the
lord.
litigation.
My lord, I understand, my lord. My lord, we'll fix it next week, my lord.
8,000 days. Other thing is this 8,000 days delay, correct?
My lord.
It has changed the entire complexion of the thing. Some things could be irreversible now. Suppose this is a matter of subject to correction, it's a matter of record of rights.
My lord.
Correct? So in 8,000 days, this period, if there has been subsequent changes, there have been alterations of the status. So it would be another thing which would make it irreversible.
To that effect, my lord, I can take instruction, my lord, whatever.
No, not instruction. There are two things. First hurdle is your 8,000 days. So the first hurdle would be 8,000 days is, in this period of 8,000 days, there have been various alterations in the record of rights. Status might have changed. Some may have sold out the property, whatever is there. There may be subsequent devolution of interest. The parties may have,
between two,
but the parties may have altered their position to their detriment if this is allowed. This we have to think of it.
My lord, may I fix it next week, my lord, my lord.
Now, supplementary affidavit, have you filed your supplementary affidavit?
No, my lord, I'm praying for some time for that, my lord.
Supplementary for what?
My lord, explaining the delay, my lord.
First of all, your application is no particulars of delay. Suddenly you wake up and found out in one morning something has happened after 10 years. Suddenly you find out that
my lord,
it was a cloudy day, suddenly the sun after 8 years of...
It's not like that, my lord. My lord, 7,000, more than 7,000 days has been taken up in the wrong forum, my lord. Proceedings in the wrong forum, my lord. The petitioner was advised wrongly, my lord.
No, that is not the issue. You have to think of the persons whose position would be greatly affected if after this 8,000 days delay we condone.
My lord.
The situation would be irreversible. So you have not filed your supplementary affidavit?
No, my lord.
So you want to file a supplementary affidavit?
I'm praying
how long?
My lord, 2 weeks time if lordship grants, my lord.
The prayer for adjournment is made on behalf of
In terms with your Lordship's last order passed from the 14th, we've issued notice upon the private respondents.
I'm entering appearance for respondent number 6. Yeah, for respondent number 5.
All the respondents are present?
Lordship,
Lordship,
six
I'm
was-
for this day.
No, all the respondents are here?
Yes,
My
yes, Lord.
5 and 6 is there.
4 is here, Lord.
I'm appearing for 4.
10 days delay.
Lordships have already condoned it.
Oh, continue.
My Lords.
No.
On the 14th itself.
Very good. Yes. What is the ground for review? What is the matter?
For respondent who I'll be required to file an
You got to file an affidavit.
filing an affidavit.
On the 14th itself, they'd made that prayer. I had indicated there was some urgency in this matter. 2 weeks was granted to them. They've not filed their affidavit as yet.
No, this was what took years. This- Where's the memorandum of review? No, it was on they are filing this review only on the ground that they were not represented nor they were heard.
My Lords.
In fact,
Now, that cannot be a ground for review. It can be you can invoke the principle under Order 9, Rule 13. That cannot be a ground to Order 47.
Lordship, may I just take a moment to just explain what's happened, my Lord?
47 is misconceived.
Lordship, I'll just take a moment. If your
47 is
Lordship will have
completely
the
misconceived.
Lordship will just have the impugned order, which is at page 180.
Yes.
It's my humble submission now that the error apparent is on the face of the record. And before that, my Lords, what's happened is
No,
I had
you
preferred
said
an appeal.
you said you are not being served, so this order is ex parte.
Yes, not just served, my Lord. It has been wrongly indicated that I was represented before the court.
So you are not represented.
I was not represented.
So
The
you
court
want a fresh
records,
hearing of this.
my Lord.
Fresh hearing of this.
Yes, my Lord.
So review
But
is
in fact-
misconceived.
Lordship.
There cannot be a review.
May I just explain, my Lord? Against this order, I had preferred an SLP.
In SLP, you said you want to file a review.
No, I did not say that, my Lord. The court has directed me to file a review. Please have the order at page 196.
So your name is not recorded here in the order?
Yes, my Lord. This is very interesting. If your Lordships have page 180, this is the order which was passed by the Honorable Division Bench. There are a total of 4 writ appeals which were clubbed together and heard by a common and disposed of by a common
No,
judgment.
were you the appellant?
No, my Lord. I was not the appellant. I was one of the respondents.
You stand on the same footing as the others.
Others. I stand on the same footing as respondent number 6 because we were disqualified tenderers.
Yes.
Our technical bid was rejected.
Yes.
Well, let's may I just take your Lordships to the memo of the appearance of the parties. Please see page 182.
What is the name of your client?
Well, it's Mariam Commerce. That is the review petitioner.
No, they say there are 4 tenderers. Your name is not there. Manakshia, then Meghalaya, then Power Roofing, and Meriam Commerce.
Mariam Commerce. That is me.
You are
I'm the
Mariam
review
Commerce,
petitioner.
okay.
Yes. So if you are your Lordships at page 180,
183. I'm on.
180, my Lord. So here
You
is
are
the list of
disqualified by the tenderer committee to participate in tender on the ground of your alleged technical ineligibility.
yes, my Lord.
Mr. D.K. Banerjee appeared for whom?
Well, it's for respondent number 4.
For us, ma'am.
For
That is power roofing.
Power roofing.
so how you are affected by this order?
Well, it's, may I just take a minute of lordship's time?
Whatever your point was there,
Yes, my lord.
this was espoused by Mr. D.K. Banerjee.
No, my lords. That's the problem. I'll just take your lordships just to acquaint the lordships with the parties.
Sorry, just a minute. Manakshi Aluminium, sorry.
Manakshi.
Mr. A. Mitra is here, present.
No, he's not here. Mr. Philemon Nongri is appearing.
I'm representing.
So the submission of Mitra was, he was representing both Manakshia and Miriam Commerce.
This is incorrect, my lords.
You are not represent. I see. Okay.
So this is what was recorded incorrectly, my lord.
But so what the review? What is the review? What is to be reviewed?
My lord, so if your lordships will just have the impugned order, page 182. 182, the appearance of the counsels of the parties indicates I was not represented in the court. If your lordships have page 182, it says none for respondent number 6. And in the connected WA, none for respondent number 4. That is Mariam Commerce. We were not represented. It is recorded in this order. However, at page 185, if my lords have it, it records in Mr. A. Mitra represented
fine.
Manakshia and
Fine, but
Mariam.
See, the court has come to see. If the conclusion is otherwise correct, just because you are not being represented will not change the complexion of the matter. It says the question which arose while hearing this appeals was, irrespective of whether you are there or not, that the learned single judge was considering reads preferred by 2 intending tenderers. So you are an intending tenderer.
My lord.
We say intending because the tenders have not even been admitted.
Lordship.
And this has resulted in the conclusion.
My lord, I would just submit 2 things. One, this is something where I was not heard. And number 2, if your lordships read the entire order, a wholesome reading of the order will indicate it was in the nature of a consent order. Kindly see page 183, the
It's not a
opening
question
lines of the order.
See, even if it is not a consent order,
No, it is in the nature of a consent order. All the parties agreed to this to these directions. Please see 183, the opening lines of the judgment.
suppose you are not part of it.
My lord.
But having regard to this paragraph, the conclusion what is there is perfect.
But I would,
Your consent is not required even. That first paragraph is no way influencing the conclusion arrived at by the London Single Division Bench. Starting from paragraph 185 where it is written, the sentence starts the question which arose while hearing these appeals. This question remains irrespective of
Lordship.
what the fair stand taken by the council or not.
Lordship. And please see page 187. The court records that it has not gone into any other questions.
Yes, exactly.
Only that limited question.
Yes,
So,
absolutely.
my lords, I had in fact moved the SLP on merit. The Honorable Supreme Court directed me to file a review. That is why I'm here,
Review on the ground.
Lordship, that I was not
If
heard.
this is see if this is the situation, then what is said in the paragraph is absolutely correct.
My lord.
It doesn't make any. It doesn't change the complexion. It says that without evaluating by the tender committee, they could not have.
Lordship.
So that you also not disputing before us.
No, correct.
So if you are not disputing before us,
Lordship.
then it will not make much difference as to the conclusion arrived at by the division bench.
My lords, just in the order of the Honorable Supreme Court, what they took note of was that the court has wrongly recorded my presence.
Yes,
and on
we
that
will
ground, they asked us to file
record
the
your
review
name.
petition.
We will record your name and we pass the same order.
I was not in. I was,
Take
it
down,
was
take
not,
down, take down, take down.
My lords, I'll just take a minute, my lord. What I'm saying is
Nothing
that
remains.
we had
Take
not
down.
otherwise agreed to these directions being passed. It was in the nature of a consent order, my lords.
Take down. District judges.
May it pleases your lordship. Item number 4 also is an application, your lordship, in the nature of review also, your lordship.
In my application,
Same order.
Same
I'm
order, your
seeking for some clarification in my application, my lord.
Same order.
My lord, lordship, I'll just point out one point.
But you are hard.
Yeah, yes. I
You are
was one
hard,
of
but
the
there is no review on
successful
this.
tenderer. Lordship, kindly see my
You can't have a
application.
second round of litigation on this.
Lordship, kindly see the order, my lord. Page number, my lord, 64 in my application.
No, but you see that you are Meghalaya Roofing.
Yes, Meghalaya Roofing.
Meghalaya Roofing was not represented.
Yes.
Yes.
So this order was passed, recording your submission that you are not represented. So that is a wrong order.
But I'm not challenging the order, my lord.
Your review petition, you see the basis, then you represent. No, this order is this an application or
It's
not
application for clarification, my lord.
for review.
No, not for review, my lord. Clarifying some part of the order. Lordship, kindly come
No,
to
what is
page
the
number
nature of
64.
your order? What is the nature of what you are seeking after you have been heard? An order is passed.
My lord, may kindly see, therefore, I invite lordship to come to page number 64.
No, please tell us that what you want to clarify as to whether of declining to take the same honest money deposit on record of the amounting to reopening, revisiting.
Yes.
If they done anything wrong, you file a fresh sheet. You cannot have the order says whatever it has to be said.
But I'm
Order
not.
says it has also to say.
My lord, I'm not disputing with that. But if lordship kindly see in the division bench order, page number 64, this Honorable Court made it very clear that
If
technical
they
eligibility.
accept this in the fresh process, contrary to the tender terms, you may file a fresh sheet. But no clarification is called for.
My lord, what happened? May just point out, my lord. I'll not take a longer time. Lordship,
You
division
don't
bench
want the
made it very
tender
clear.
process to go on.
Lordship,
You
division
don't
bench
want a
made
tender
it,
process to go on.
division bench made it very clear that the technical eligibility of the respondent
Whatever is
for
there,
me
sorry, Mr.
would not be
Counsel.
revisited.
We will
But
not
now
allow
the
this
state
kind of we will not allow this kind of second round of litigations,
But-
third round of litigations, not allowing
But
the
the state is
tender
trying to-
process to continue.
State is trying to revisiting the technical eligibility of the applicant here. That is the only grievance.
No, if they revisit it, you file a fresh cause of action if you have any, not by of this. Take down.
Wait, please, your lordships. My lord. My lords, in pursuant to the last order, we have taken steps upon the respondents, and the respondent number 6, my learned friend, today, my lord, perhaps will enter appearance.
for the
Respondent
respondents.
6, I'm entering appearance. I'm filing my vakat in the course of the day.
Number 6.
6.
1 to 5.
1 to 5.
Your Lordship, I appear for respond number 1 to 5, my lords.
You are for?
Respond number
My lord,
1
my
to 5,
learned
the state
friend
respondents,
is
my
on
lords.
mute, I think, my lord.
He's for 1 to 6.
1 to 6, 1 to 5.
1 to 5, 1 to 5, my
5,
lords.
he's for the
You are
state.
for the state.
For the state respondents, my lords.
Yes, my lord, he's on mute. You're on
Your
unmute.
Lordship,
unmute.
it's unmuted from my side, my lords. I'll just.
Yes.
If my lords can hear me now, if I'm audible now. Sorry, I'll join from the lords.
Can't hear you.
That's
Anyone is there
I'll-
for the state? You are assisting him.
Yes, sir.
No, assisting him.
No, my lord. I'm not aware of this.
Pass over.
Is he not in court?
No, my lord, he's in
So
Delhi.
he's appearing from Delhi, man.
From Delhi. My lord, we can rejoin again if we can just log off and
I'll do that.
Log up and rejoin.
Yeah, I'll do that.
Because they are supposed to take instruction.
Yes, my lord.
Respond number 1 to 5 are you?
No, it's my friend who's appearing for the
You
state.
are for 6.
I'm for 6, my lord.
Who is 6?
That's the MTDC, my lord. Meghalaya Tourism Development
Oh,
Corporation.
okay. TCR has come. TCR has come. TCR has been connected on behalf of that. Yes, can you hear us?
Still he's, my lord, not audible.
my lord, he's saying that he's audible to the others but not to the courtroom.
We can hear him. We can't hear him now.
Yes, we cannot hear him, but to others he's audible.
I can also hear the courtroom.
The same problem with the other VCs also.
Not even next 18th. 18th, maybe. Difficult.
No, what is the instruction?
Last night, a counsel from the state appeared.
Please be here physically. Please make some arrangement.
I'll send someone.
Financial matter, please be here.
I'll send someone.
Due to technical glitch,
My lord.
the land council for the respond numbers 1 to 5 on the virtual mode. What did I say? No, the land council for the respond numbers 1 to 6 is 1 to 5 is appearing on the virtual mode. However, due to technical glitch, he is inaudible.
Appellant, my lord. So this is an appeal which has filed against an order dismissing a Section 9 petition under the Arbitration Act, my lord, in which we had challenged the illegal termination between the appellant herein and the state of Meghalaya. The appellant herein was had entered into a MOU in 2019 for operating a diagnostic center, my lord. There was an termination without following the terms and conditions of the MOU. Challenging that, we had filed a Section 9 petition, which was dismissed on the sole ground that the appellant is not a party to the MOU, my lord. But whereas the specific case is that for 4 years, the appellant have conducted the business, all licenses have been issued to the appellant,
No, but you have to be a party to the agreement.
My lord?
If you are not a party to the agreement, you cannot invoke.
We are a
Section
party
9.
to the agreement, my lords. We are a party to the MOU. My lord, and pursuant to that,
The MOU contains an arbitration clause.
Yes, my lord. MOU contains an arbitration clause. We are a party to the MOU, and thereafter, my lord, when this matter was being heard before
Is
this,
there any agreement between the state of Meghalaya and your client?
my lord, that's executed in June 2019, wherein we are the parties, and thereafter, my lord, certain terms. Thereafter, in the course of the hearing, this honourable bench had directed that whether any settlement can be entered into to be worked upon. So we had submitted our terms of settlement in 10th of June. Thereafter, certain discussions have taken place. Now the state on that, if your lordship will kindly consider the last order of 10th of September. So on 10th of September, the ultimatum was given to the state to respond that whether they are confirming our settlement or no. So we are yet to instructions from the state that whether the settlement is on course or they are not considering the settlement, and then we can proceed with the matter, my lord. This is the situation standing as on date. And also in this matter, like my lord, this honourable bench.
Yes, so what is
Yes, my lord, I've been led by the senior, by the colleague who's there on virtual. I do not know if he...
Milords, am I audible?
Yes, you are audible.
So, Milords, that is an incorrect submission. They were not party to the MOU, first of all. And that is the primary basis why the commercial court rejects their Section 9 petition. That is point number one. And as far as Milord's settlement is concerned, there were talks of settlement, but the invoices that were sent by them were checked by our chartered accountant, and we did not find them to be genuine. So, Milords, as settlement talks have ended there, so there is no possibility of any settlement in this matter. The matter, Milords, has to be heard in entirety then.
So then let the confirmation come from them, because this is in the court they are saying that they will not proceed with the settlement.
So you make an official communication to them.
My lords.
Milords, we'll do that.
If they have given a terms of settlement, then they have and according to you that Section 9 is there is no agreement between the state of Meghalaya and the petitioner.
Yes, my lords, there is no agreement. In fact, that is admitted in the Section 9 application itself. And this project, my lords, was for the purposes of the Shillong Medical College, which has started. This is the first medical college of the state of Meghalaya.
No, they are diagnostic center. They are diagnostic centers.
They had a diagnostic center, my lords. I don't know whether they had the diagnostic center or who are the real parties, but there was a diagnostic center at the premises, and that diagnostic center was
there's diagnostic center inside the medical college.
No, my lords.
My lords, it is the civil hospital which was one of the blocks was given for the diagnostic center, and later it was proposed for the Shillong Medical College. And independently of that, the agreement was not being complied by the diagnostic center. That was the primary reason for termination in this matter, my lords.
My lord, initially there was the MOU was entered in 2019 between the state and the appellant herein for operating a diagnostic center. The diagnostic center was being operated. Thereafter, the state wanted to establish a medical college sometime in the middle of 2024. They wanted to establish a medical college in the very premises which was given to us for the purpose of running the diagnostic center. Thereafter, a minute was called wherein we were told that kindly leave the premises, amicable termination and everything. We did not agree to that. They wanted to utilize the premises which was given to us for the purpose of running the diagnostic center. They wanted to utilize those premises for the medical college. So for which we did not agree for an amicable termination. Thereafter, they
obviously they will make their communication to you. But the Section 9 was dismissed on the ground that you are not a registered limited liability partnership.
My Lord,
registered under 2008. If you are not registered, whether
I am a registered party, that's a wrong submission. That's a wrong finding which we are challenging before this. The
formulation, the points formulated by the division bench, previous division bench, is that you are not registered under the Limited Liability Partnership Act 2008 and not a party to arbitration agreement. So in these 2 points, if you are through, appeal succeeds. If you are not,
my lords, we will ready to answer this, my lords. Let them communicate the official closure of the settlement, and in this matter, I am also being led by Mr. Jishnu Shah. So your lordship will fix up a matter. He will be here physically, and he will be arguing out the matter in entirety, my lords.
Sit down. Mr. Addi, the Land Counsel, appearing on behalf of the appellant, has submitted that
Please, your lordships. Lordships, I'm seeking for an accommodation. Lordships, today I'm being led
accommodation. Why, madam?
Lordship, I'm being led by Mr. Paul. Lordship, he's not well. He's not keeping well, Lordship.
It's a short matter.
Lordship,
recalling whether power of recalling is there, isn't it?
Lordship, this is the...
And you have power, and it provides for appeal.
For determination on the preliminary issue of maintainability, Lordship, yes. Lordship, I'm praying if...
You have an appellate forum, madam. Why don't you go? Last time I have indicated to you.
Lordships, I'm under very limited instructions today, Lordships.
Yes, on the earlier occasion, we adjourned this on the ground of Mr. Paul. Very well. Take down. You are appealing?
No, my lord.
Who is appealing for this? Okay, very well.
Power
An
corporation.
adjournment is paid for on behalf of Mr. K. Paul, senior advocate, as he is presently indisposed. The matter stands adjourned till